it is such a wonderful, can I stand off to the side so I don't get the projector in my eye? Hi, Lee. It's such a wonderful privilege to be back here and talking to you all again. I haven't done this for a while, and it's so exciting to be talking about such a fabulous issue. I was reminiscing with somebody about some work that we had done on the No on One campaign in 92 through 94. And shortly after that, I can remember that Evan Wolfson, who was at the time the Director of Land, Legal Defense and Education, and who I had gotten to know because he was working with National ACLU, and we were all ready to file a lawsuit because we thought Prop 1 here in Idaho was going to pass. And we were ready to file the morning after the election, and we thankfully didn't have to, but I got to know Evan then. He's the founder and executive director of Freedom to Marry, and he was doing a speaking tour throughout Idaho, and he had just formed Freedom to Marry at that moment in time, and I just remember him talking to him saying, Evan, marriage, are you kidding me? What's the road? How do we get there? We've got to deal with all this other stuff first. Who would have thought it? Who would ever have dreamed that we would be where we are? The pace of change has been so phenomenal on the issue of lesbian and gay rights. I'm thankful for that. It turns out my son is gay, and I think maybe it was just a message to be involved in this from the very beginning, because it would be paving a road that would be smooth for his life. So this is a personal topic for me, one that I've been involved in for a long time. Many of you know, and Linda said, I'm involved in the ACLU, and this big clash up between my professional life in the world of family law and my little volunteer life on ACLU is also just, I think, wonderfully fortuitous. So where are we? And what do we think is going to be happening? And I could talk a little bit too about add the words if people have questions at the end. But we didn't know kind of that the hearings would be right now. So my count's off a little bit. Alabama should have red stripes on it. But we've got same-sex marriage in all but 14 states. Wow, who would have thought it? Of the 14, a number of those states are awaiting, have favorable judicial rulings that are awaiting final action. Many of them are stayed, waiting for the pending outcome of the U.S. Supreme Court case. So it's really kind of a phenomenal change that is going on. And just sort of talking about where we were, I would talk to you a little bit about the case law that's been out there and what the U.S. Supreme Court is going to be looking at when it considers the DeBoer case and the DeBoer case itself, and just kind of what I think the really big issues are. So the main case they're going to be looking at is Windsor versus the United States. This was a case they decided in 2013. And the majority opinion was written by Justice Kennedy. He's written all the majority opinions in most important recent gay rights cases. And he was joined by Ginsburg, Breyer, Sotomayor, and Kagan in this particular opinion. Roberts dissented, kind of doing his own little thing, and I think he is an unpredictable vote in this upcoming case, as I do think Kennedy is slightly unpredictable for reasons I'll talk about as we go on. Scalia wrote a separate dissent. He was joined by Thomas and also by Roberts, and Alito was in there with a separate dissent joined by Thomas. Alito and Thomas are kind of way out there on the right. I don't think they'll have very much impact on this next decision. Scalia too, for his own reasons, but Roberts is a little bit unpredictable. So in that act, the court was reviewing the constitutionality of the Federal Defense of Marriage Act. And the Federal Defense of Marriage Act has two different sections. It does two different things. And only one piece of it was up on review in that case. So the act says to the states in Section 2, you're allowed to not recognize the official enactments of other states on the subject of gay marriage. So normally, we have full faith and credit among the states when state A makes an official enactment, like giving a marriage certificate or recognizing a marriage. Other states are required to give full faith and credit to those official state enactments of state A. The full faith and credit clause also gives Congress the power to enact laws to ensure full faith and credit happens. And they do that. They do it in the area of child custody jurisdiction, for example, just a real common area that if you know anybody who's had interstate custody issues, they probably relied on some of those enactments. But this time Congress used its power to say something that was not ensuring full faith and credit, but actually for the first time in the history of the Congress's exercise of powers under the Full Faith and Credit Act clause, they exercised their power to pass a law saying, we don't want to ensure full faith and credit. In fact, we're going to say to the states, you can all do your own thing. So that's Section 2 of the Act. That section was not on appeal in the Windsor case. Section 3 of the Act was, and Section 3 of the Federal Defense of Marriage Act established a federal definition for marriage. Again, a pretty radical thing, actually, because one of my themes here is going to be that family law, issues involving families, marriage, divorce, child custody, has been historically viewed by the federal courts and by the legislature as being an area that is quintessentially within the domain of the states to make enactments. And historically, the federal government has really not acted in the areas of family law. They really have been very restrained. The only times you see them taking action in the area of family law is when the family law issue is entwined with some federal issues. So, for example, there's a couple cases regarding pensions because Congress regulated the national market for pensions in a big statute that many of you might have heard of called ERISA. And that affects family law. Divorce courts are out there dealing with pensions. And so Congress passed some legislation to make that go more smoothly. Or to ensure that we wouldn't have interstate competition among the different states in child custody and child support. Congress has made enactments in that area. But really, the times when Congress or any federal entity has taken actions that regulate family law, they are few and far between. It is one of the few remaining areas of pretty much exclusive state domain in which Congress has continued to exercise a lot of discipline and not taken action. And I think this restraint and the idea that family law is quintessentially the state law area is sort of a thematic thing in these gay marriage cases that a lot of people in the general public don't kind of get a handle on. But it's really pretty radical. So for Congress in Section 3 of the federal DOMA to step out and say, we're going to define marriage for federal law, because feds always refer to the states for purposes of filing your taxes or getting benefits under Social Security. There are no federal definitions historically of marriage and those consequences. If you're married in a state, you're married. Period. In all the states, and for the federal government, and for every federal law that is based on marriage. Okay? You get a common law marriage in Pennsylvania, you get a ceremonial marriage in Idaho, doesn't matter. Got to be above 18 in this state, got to have blood tests and that, it doesn't matter. First cousins can marry in state A, they can't marry in state B, doesn't matter. Feds have always used those state definitions and never had their own definition, ever. So Section 3, it's a pretty radical enactment. So in the Windsor case, the facts were interesting, and I actually think it's facts like the Windsor case that are going to drive these sort of situations. You had a couple, they had been together for a very long time, since 1963, in a long-term committed relationship. Windsor's health, or Spader's health was bad. And as a result of anticipating issues, they wanted to try and secure their relationship as best as they could. And so in '07, they traveled up to Canada, where marriage was legal, and were married in Canada. So that at least for some purposes, if there were some states that would recognize it, and actually they lived in New York, and at the time, New York did not recognize same-sex marriage, but New York did recognize the validity of same-sex marriages performed in other states and countries. So that New York said, we're not ready to let you do this marriage here in New York yet, but if you go someplace that is, we will respect your marriage. So the Canadian marriage was going to be very helpful to Speyer and Windsor as they anticipated their estate planning and Speyer's death. But what happens is they file this estate tax return, and Windsor cannot claim to be a surviving spouse. And as a result, they owe a ton of estate tax, over $300,000. So she pays the tax, and then requests a refund, standard procedure, and then sues when the feds say, no refund, you're not married under our federal definition. Even though Canada says you're married, and we would normally give respect to Canadian enactments, and New York would respect your marriage, you're not married for our purposes, and they sued. Okay, so the two key aspects that the court walks through first, well, not two, more than that, but first, Justice Kennedy, in the majority opinion, stresses that, and this is important because Kennedy's vote is crucial in the upcoming case. Kennedy stresses that marriage and family law is traditionally reserved to the states, that the feds have deferred to the states, that the courts have only upheld these very limited incursions, some of which I mentioned, into the authority of the states, where there are important federal reasons on the topic of family law. But he also says states must respect the constitutional rights of persons. They can't violate civil liberties with their state enactments. So Kennedy's opinion in Windsor says, Section 3 of DOMA, it's inconsistent with the state's authority to act in family law. There is no countervailing important federal policy out there that would dictate this kind of incursion into state family law power, okay? Which, by the way, I'm seeing people write notes, and Karen, right in back of you on the table, I wrote copies of my slides, and I forgot to pass them out, so I'll let you guys pass them around. Sorry about that. I've got 30 copies, so I think we'll just barely maybe have enough. So he says, so it's really interesting to understand that Windsor, our main precedent case, isn't really clearly a civil rights case. That when you read the opinion and you look at what the basis for the court's decision is, it's a federalism case. It's about when do the feds get to take actions that are regarding family law topics, an area particularly reserved to the state. DOMA was exceedingly unusual. And so it's not a surprise that Kennedy, a conservative, Republican-appointed justice, focused on these federalism issues in writing his opinion. I have a feeling he also was really trying to get Roberts' vote, and he almost does, I think. That's my read on the opinion. But in the end, Roberts dissents, okay? All right. It's not that the Windsor case is devoid of civil rights types of reasoning. So Kennedy also talks about how the DOMA sought to disadvantage the very persons New York sought to protect with its statute. Again, kind of putting this federalism twist, but talking about the impact on individuals and talking about disparate treatment that is motivated by improper animus. And I'll come back to that because that motivated by improper animus comes from Kennedy's two prior important gay rights opinions Romer versus Evans and Texas against Lawrence. I've got a slide on that. Okay, so it's the same reasoning from those cases. And factors, he says, showing animus, that there was just, this legislation was motivated by dislike for gays. He says that it deviates from this profoundly important principle of federalism regarding family law, and why would you do that for when there's no other policy other than to stick it to LGBTQ people? He says the text of the statute and its history indicate that they wanted to interfere with the equal dignity, and that was more than an incidental effect. He looks at some of the legislative record, some of the statements that are made. I kind of quoted a couple of them. Legislators talked about how we needed the legislation to defend traditional heterosexual marriage, that same-sex marriage is a radical proposal, and one person wanted the legislature to adopt a resolution that the House expresses moral disapproval of homosexuality. So just a few examples of the statements upon which Kennedy relied in saying the process of passing the federal DOMA involved this kind of animus. And he said that the effect of it is to write inequality into the entire U.S. code. Some marriages are going to be respected by the feds, other marriages are not going to be respected by the feds. But he also said this opinion and its holding are confined to lawful marriages. In Windsor, Kennedy really disclaims, or it tries to disclaim, I think, that Windsor itself is deciding the marriage question, whether same-sex marriage is constitutionally required or whether banning same-sex marriage would violate the Constitution, okay? So there's these two other cases, Romer versus Evans. This was the Colorado Amendment 2 case. Many of you remember that. It was passed by Colorado a year or two before our own Proposition 1 went on the ballot in the fall of 1994. And it was a very similar piece of legislation that was aimed at fencing lesbian and gay citizens of Colorado out of civic life in Colorado. And it was declared unconstitutional in a 6-3 decision. Different court, so we still have Kennedy, Ginsburg, and Breyer on the court, but this opinion also had Souter, Stevens, and O'Connor joining in it, and those three are not on the court anymore. We've got Kagan, Sotomayor, but we picked up Alito and Roberts too. So, okay. So, but Romer is where Kennedy forms this animus test. He says, basically, that the U.S. Supremes have always said that a minimum test for whether legislation is constitutional when it affects civil liberties is that it has to be rational. The means that Congress chooses, well, they mean something pretty, the means that Congress chooses to affect the civil liberties have to be reasonably related to the ends they're trying to accomplish. Okay? This is a very low test. And prior to these cases, the Supreme Court had really only ever struck down 1 or 2 pieces of federal legislation by saying it didn't meet this minimal level of review, okay? But generally, you know, the legislatures out there, they're elected by the people. We are a democratic country in which majority rule matters. And if this group of 9 justices is going to come in and veto what Congress is doing, we've got to have some pretty darn good reasons for doing so. So as long as Congress is acting within the very broad outlines of its authority and acting rationally, the general rule is the court doesn't interfere with that legislation. Only when we have certain factors does the scrutiny get higher, does the court look behind the legislation and say what else was going on here. Well, Romer and Texas and the language in Windsor really start to change the landscape. I mean, one of the things to understand is that there's a huge shift, I think, going on in how the court views its role in reviewing legislation on the civil liberties issue. Because in these cases, Kennedy, first of all, does not go to any of the traditional civil rights types of reasoning to strike down the bills. He doesn't, if you're reading reviews of what the court's doing, you're probably often seeing in civil rights cases that the court applied strict scrutiny or that a state had to have compelling reasons. Those are terms that the court uses for saying, look, legislature, if you're going to pass legislation that affects civil rights, the first 10 amendments, rights guaranteed by the first 10 amendments, you got to have better than rational reasons. Okay? And we might interfere with you then. Normally we don't, but we might then. But in these cases, Kennedy says he's just applying the rational reasons test. Okay? And he says that the legislation is basically not meeting that test because it is so profoundly motivated by animus, by hatred directed at a particular group, that it cannot be viewed as rational legislation. He forms that test first in Romer, and they strike down the legislation. He said there is just no rational reason for legislatures to be passing legislation that is so motivated by dislike and hatred and bad motivations directed at a particularly identifiable group of people.